Good afternoon and welcome to this IFOA seminar on the general implications for our members of GDPR. And we're focusing on our members operating predominantly in the UK but internationally as well. Good afternoon. You join us here at our IFOA offices here in a rather damp Friday afternoon in London. My name is Des Hudson. I'm chair of the Regulation Board and going to be chairing the webinar this afternoon. And I'm joined by my colleague here, Martin Sloan. Martin is a member of a leading law firm here in the UK, based in Scotland, Brodie's LLP, and he specialises in commercial services activity, but in particular, I think he's widely regarded as a leading expert on information law, advising clients across a range of sectors, and in particular advising those clients on data protection, compliance and information security. And he's actively involved in advising a number of clients on helping them in their preparations for the general data protection regulations. Before I pass to Martin and his presentation, let me just remind you that you have the opportunity to ask questions at the end of Martin's presentation. So now's the time, if you have a question or as the webinar proceeds, to start typing and get that question over to us. Now, in order to make sure that you're logged in properly and you're receiving all of the functions of the webinar, what I want you to do, if you will, is help me in 4 short survey questions. And I wanted to start by asking you to tell us what's your main practice area. So if you vote and submit that vote in response to these 4 questions, you'll see the responses from all other colleagues on this webinar. And as I say, it'll help you to make sure that you're fully connected, and it will help us to understand where the participants for the webinar are coming from and their interests. So that first question, I think we've got a number of people voting, so do get your vote in now. Let's see where we're at. At the moment, the majority, Martin, I think, are based in pensions as their main practice area. Almost just over half of all the colleagues listening into this webinar are involved in pensions. So, thank you for that. If you want to make a vote, do it now. I'll give you a couple of seconds. So, as I say, comfortably over half of all of you listening this afternoon are involved in pensions. Let's go to the next slide, if I can move us on. And that is, oh, forgive me, I think I may have gone one too many. And that is asking you which of the options that we list below best describes the type of organisation that you work for. Again, as I say, that will help Martin and I in structuring the presentation and responding to questions. So, cast your vote to this second question if you would, please. Okay, so over 3/4 of you are involved in actuarial consultancy, about 1/5 working for an insurer or reinsurer or an insurance company. Okay, I think more or less all the votes are cast there, so thank you for that. I'm going to move you to our third question, and here we just want to check where your role is based. Are you in the UK or outside the UK? And again, that's going to help us in framing the materials and some of the examples that we use. So let me ask you to vote for this third question if you would, please. So almost all of us listening to the webinar, 96% are inside the UK. So welcome to colleagues who are joining us from outside the UK. So final question that I'd like you to respond to is we'd like to assess your firm's state of readiness in terms of preparations for GDPR coming into effect on the 25th of May. You'll see the range of options there. You've got still work to do. You are 100% ready, or you're not quite sure. So let me give you a second or two to get those answers in. Okay, Martin, looks like good news for you and the rest of the legal profession. Best part of 82% of our webinar participants have got still work to do. So thank you for taking part in that quick summary. So let me hand over to Martin.
Thanks, Des. So what I'm going to take you through this afternoon is 3 sections in this presentation. Firstly, just a little bit of data protection basics. So just a refresher for those of you who are familiar with data protection law. For those of you who are less so, just taking you through some of the basic building blocks in the terminology I'll be using over the next 40 minutes or so. Then I'm going to go on to talk about the general data protection. So that's the main topic of this afternoon's presentation. Its background to it, and take you through some of the key changes. And then we'll finish off with a couple of slides looking at steps to prepare for our GDPR before I'll hand back to Des, who will chair the questions as they come in. So, kicking off with some data protection basics. So the current law that we have is based on a directive from 1995, the EU Data Protection Directive, and in the UK that was implemented by the Data Protection Act in 1998, and similar legislation exists in other EU member states. And current data protection law, and as you'll see, GDPR applies to what we call controllers who process data that is personal data. So what do we mean by those terms? Well, the controller is the individual or the legal entity that determines the purpose or the reasons for which the data is being processed. So it's the one that actually has control and decision making over that. And for most of you, that will be your employer, though, as we're going to see. If you are being personally appointed as a scheme actuary, then you may well be, you're likely to be a controller in your own right. A processor is someone who's processing on behalf of a controller, so another legal entity who's instructed to carry out processing of personal data on the instruction of someone else. Processing, well, that's basically anything you can do with data, even if you have a file which you stick in a filing cabinet and leave it there for 10 years and do nothing more. That is processing and therefore regulated by data protection law. And personal data, what do you mean by that? Well, it's anything which relates to an identified or identifiable living individual. So it only applies to people when they're alive. Once you're dead, data protection law doesn't protect your data anymore. And it's basically anything which can be identified with that individual. So those are the basic building blocks, and I'll use that terminology as I go through this presentation. As I mentioned, you can be a controller and a processor, and the distinction is quite important. So at the moment, processors have no direct obligations under current data protection law. They simply have to comply with the contract that they have in place with a controller. So it's very important to understand in relation to whatever it is that you or your organisation does, whether you're doing that as a controller or as a processor, or perhaps as a joint controller with another controller where you are processing for a common purpose. So if your organisation is a controller and you're deciding how and why personal data should be being processed, then you are responsible for compliance with the law in relation to that processing. And you're also responsible for any processing carried out by a processor on your behalf. If you're a processor, then say you're processing on behalf of the other organisation and you don't have any direct obligations in relation to that under law, though you will, as I say, have to comply with the contract that you have. And it's worth noting that certainly in the eyes of the Information Commissioner in the UK, generally most professional advisors are viewed to be controllers in their own right rather than as processors. So it's very much a case of looking at what it is that you're doing and in what capacity is to identify whether you're a controller or a processor. And I mentioned before on scheme actuaries, I say where there's a personal appointment for the scheme actuary, then in the eyes of the Information Commissioner, the scheme actuary will be a controller in his or her own right. That may be alone, or it may be acting as a joint controller with his or her firm, depending on the nature of responsibilities and who is doing what. So it's very important to understand what your role is and what you're doing. So the General Data Protection Regulation comes into force on Friday the 25th of May 2018, so we are now less than 80 days to go, or 53 working days if you choose to count it in that. So very much coming close to the date and when it comes into force. And as I mentioned, the current law is based on a 1995 directive, so this has really been 20 years since the last refresh of data protection law, and in that time the way in which organisations across all sectors use data and the amount of data we are creating has changed hugely. And the intention therefore for the GDPR is to refresh and update data protection law for the digital age. As I say, it comes into force in May this year. It's also important to note that it is a regulation rather than a directive, and that means that it has direct effect in member states. So we will have a single text which applies automatically, so there's no need for something like the Data Protection Act to implement it in the UK, or whichever member state you're in. The core text applies automatically. And that, together with provisions to ensure consistency in regulatory interpretation across the EU, should mean that for those of you who operate in multiple member states, you are able to actually adopt a single unified approach to data protection law compliance, and you won't need to necessarily deal with so many different approaches in terms of local legislation or local regulatory interpretation. In addition to the stronger coherent framework, we've also got far stronger enforcement powers for the regulators. So the Information Commissioner in the UK and her peers in other member states. Brexit has no impact on GDPR, so it will come into force in May this year. And under the EU withdrawal bill, the GDPR will automatically become part of UK domestic law upon Brexit. There will be, although I mentioned that GDPR has direct effect, there will be some national implementing legislation. So there's a bill working its way through the UK Parliament at the moment, the Data Protection Bill, and that will deal with some of the local implementing issues around GDPR. So the powers of the Information Commissioner, setting out some of the legal basis of processing, and some of the other stuff where member states have discretion as to how that is implemented. So it's important to understand how those two bits of legislation fit together. And finally, just a word on e-privacy. So at the moment, the rules dealing with electronic marketing, so marketing by email or by text message, or doing things like using cookies and online tracking technologies, those are dealt with by an additional piece of legislation that sits alongside the current data protection law. And that legislation will be updated at some point over the next year to 18 months. The original plan had been for all of this to come into force on the same day, but the text of that is still to be finalised. But just to be aware that changes on electronic marketing are on the horizon as well. So why does all this matter, and why are we sitting here and talking about it today? Well, I guess there's four areas where it creates risks. Firstly, there's a compliance risk. So this is the law, and you'll want to comply with that. And if you don't comply, then that raises the risk of regulatory enforcement action. I'll talk a little bit about the powers that the regulator has. Secondly, there's financial risk. So those powers, regulatory enforcement powers, may lead to monetary penalty notices. But even if the regulator takes no action, you may still find that you have increased management time dealing with a data breach, or compensation payments to data subjects who are affected by that, and other cleanup costs. All of these things can have a financial impact. Thirdly, there's the operational risk. So one of the new things that comes in with GDPR is the ability for the regulator to issue powers to order organisations to stop or suspend processing. And if your organisation is hit with one of those orders whilst an investigation is undertaken, that could have a material impact on your ability to actually carry out your business. And then finally, reputational risk. So data protection is all about trust and reputation, and it is if your organisation suffers a data breach or is known not to handle data properly, then that could have an adverse impact on your reputation in terms of media coverage and trust with individuals, but that could also then impact on clients, customers who want to do business with you. If they don't trust you with their data, then they may choose to take their business somewhere else. So I say all of this matters for a number of reasons. So although there are a number of changes coming in with GDPR, I think it's important to remember that for most organisations who are currently complying with the existing data protection laws, it should be a case of evolution, not revolution. It's very much the core principles that we have at the moment remain the same. It is simply enhancing some of the obligations that sit around those. And things like terminology, so I talked before about the definitions of personal data and controller and processing, all of those core terms remain the same under GDPR. So if you understand those terms at the moment, you should understand and be able to pick up GDPR fairly quickly. The data protection principles that we have at the moment are largely recognisable under Under GDPR, they have changed a little bit, and I'll talk you through those. The conditions for processing, so the legal basis upon which personal data can be processed, again, these largely stay the same with some tweaks. So again, there shouldn't be much of a change there, provided you know what it is you're doing and why you were doing that. The rights of individuals, again, the rights they have at the moment are carried forward, and those are all recognisable. There's some new ones, and I'll talk about those. If you transfer personal data outside the EEA, then the basic framework and the rules for doing that are largely unchanged. So using things like standard contractual clauses or binding corporate rules, all of those provisions will continue. And in data security, there's no change to the basic obligation to put in place appropriate technical and organisational measures to protect data. That test, that requirement in that test doesn't change. What does change is the consequences of the sanctions if as an organisation you fail to comply with that principle. And finally, we will still have in the UK the Information Commissioner and the fellow regulators in other EU member states. We will still have national regulation of data protection law, albeit that the law itself is uniform across the EU. So what is changing? Well, there's two key principles which come in under GDPR. The first of these is in relation to transparency, and I'll talk a bit about that. It's an obligation to demonstrate compliance, and some of the other things that as an organisation that you will need to do to comply. So that's been much clearer with individuals about how you're processing data and ensuring it's done on a fair basis. The second principle I want to talk about is around accountability, and that's your ability to demonstrate your compliance and some of the tools and levers you can use to demonstrate that compliance. Thirdly, there's an emphasis on record keeping and administration, because if you don't keep good records and you don't know what you're doing, how can you comply? How can you demonstrate your compliance? Fourthly, there's some new rights for individuals, and I'll talk a little bit about those. Fifthly, we've got some organisational principles that come in. So data protection by design and data protection by default. And these are the principles which mean that you should be hardwiring privacy and data protection into any new project or any new service or anything new that you're doing from the outset. So think about the privacy issues at the beginning rather than as an afterthought. Designing so you're collecting the minimum amount of data necessary for that purpose, and setting settings or choices to be the most privacy friendly at the outset. Breach notification is another new requirement under GDPR, and I'll talk you through when breaches need to be notified to the regulator and potentially to individuals. And then finally, on sanctions, again, I mentioned this a couple of times, I'll talk you through the new powers the regulators have and what you need to be aware of there. So before going through that, it's maybe helpful, particularly for those of you who are listening or watching in today from outside the UK, to understand the territorial application of GDPR. So it applies to any organisations who are established within the EU, and that applies regardless of whose data you're dealing with. If you're established in the EU, then GDPR will regulate what you do with personal data. And by establishment, that may not just be having a company or an office here, but actually some sort of presence doing something. So even potentially a branch office may be enough to trigger an establishment. But it also applies to certain organisations who are outside the EU as well. So if you carry out processing, and that relates to offering goods or services to individuals within the EU or monitoring their behaviour, then you will be caught by GDPR as well, and that applies to both to controllers and processors. And whilst talking about processors, the other big change with the scope of GDPR is that it introduces new obligations on processors, and I'll talk a little bit more about those later in the presentation. So as with the current law, data protection law is built around a number of what we call data protection principles, and I'll take you through what the principles are under GDPR. So the first principle is the principle that any data should be processed fairly and lawfully and in a transparent manner. And that's a key principle, ensuring that what you're doing is fair and that you're being clear and transparent with individuals about how you're using their data and what you're doing with that. And I'll talk through some of the changes that apply there. The second principle is that you should only use the personal data for specified purposes, and you shouldn't then use it for a new purpose that is incompatible with that original purpose. So it's very important at the outset to be clear about why you're collecting data and what you might want to do with it, because if you're not clear at the outset, you may find that you're unable to use it for those new purposes without going back to the individual and telling them what it is you are going to do with that data. Thirdly, the data that you hold should be adequate for the purpose and limited to what is necessary. So you shouldn't be holding more data than you need for the purpose in question. Fourthly, that data has got to be accurate and where necessary kept up to date. So there's an obligation to ensure that whatever data you hold, you keep up to date. Think about how you deal with that with the individuals whose data you hold. How can you ensure that that is kept up to date? Fifthly, you should only hold that data for as long as is necessary. So once that purpose has come to an end, you shouldn't be holding that data any longer. So this is about data retention policies, data destruction policies, and ensuring that once that purpose has come to an end, appropriate steps are taken to delete or destroy that data. And then the last principle is around integrity and security. So an obligation to keep that data secure and confidential. And as I mentioned, one of the things coming with GDPR, and you'll see that in the 7th principle there, is to actually be able to demonstrate your compliance with all those principles that I've just been through. So not just actually complying with them, but actually being able to demonstrate how it is you're complying with that. So what does that mean in practice? Well, I think in practice what it means is implementing appropriate policies and procedures within your organisation to ensure that data is handled correctly. So that might be data retention policies, it might be data collection policies, it might be training for staff to help them understand what they should and shouldn't be doing. If you have to share data with another organisation, how is that being done? Is it done using an encrypted USB stick or encrypted file transfer or whatever? So all these sort of policies to show how you're actually ensuring the data is handled properly and in accordance with the principles. I talked a little bit about data protection by design and default. I say that's building these principles into your organisation when you carry out new activities. Another important tool, something which is required in certain situations, is what's called a data protection impact assessment, which is a risk analysis of new processing activities, and I'll talk through that in a little bit more detail. And there's also an obligation to keep appropriate records. So that's records explaining what processing you carry out in relation to what data, how long you're keeping that data for, how you're keeping it secure, who you're sharing it with. And it's very important as an organisation to be able to actually have that registered or record that you can consult and you can show to the regulator to show that how you're actually going about your compliance. And finally, there's an express obligation to cooperate with regulators. So if the Information Commissioner comes along and asks you some questions, you need to liaise with them on that. One of the other accountability requirements is in relation to what we call a data protection officer. And these are not mandatory for all organisations, but if your core purposes involve processing sensitive or special category personal data, so that's information relating to health or criminal records or sexuality or religious beliefs and things like that, then that will trigger a requirement to have a data protection officer. Similarly, if you carry out regular or systematic monitoring of data subjects on a large scale, and those are the words from GDPR, we have a little bit of guidance that explains what that means in practice, then you would also have to have a data protection officer. But actually for many organisations, even if you don't have a clear and definite requirement to have a data protection officer, it just makes sense to have someone within your organisation who you have tasked with helping to ensure that your organisation complies with data protection law. Given the burden in terms of compliance, it makes sense to have someone who has that responsibility. Your data protection officer has to have expert knowledge and skills both of the data protection law but also the industry in which you operate to understand how personal data is used within that industry. And it's very important they're allowed to actually carry out their functions in an independent manner. So that means being able to directly report concerns in the board level rather than having to report into through someone else who may suppress those views. So they have to be able to actually highlight those concerns at the appropriate level so that action can be taken. And there are also rules around conflicts of interest as well, such that the data protection officer shouldn't be marking their own homework. So you couldn't have a head of IT or a head of operations or someone who has a role involved in actually using or handling personal data who is then also responsible for policing their own compliance. So the DPO role needs to sit sort of one step away in some form of compliance function, and it's important that is provided for within your organisational structure. The role of the DPO is very much around sort of general advisory, carrying out training, reviewing policies and helping to ensure the organisation is compliant, but also being that point of contact if anything does go wrong and taking the appropriate action at that point. And you can outsource it or you can share it with other organisations within your group. That's perfectly permitted, provided the individual in question has appropriate access to information and people and resources to do that. Data protection impact assessments are something which certainly in the UK the Information Commissioner has advocated as best practice for a number of years, but I know anecdotally speaking to clients and other organisations that they are not as widely used in practice as I think the Information Commissioner would like. They are mandatory under GDPR if you're carrying out what is referred to as high risk processing, and again the regulators have provided some guidance on what that means. But they've also said that actually it makes sense to carry out a DPIA in all circumstances. Whenever you start a new service or do some new processing or procure a new bit of IT or a new system, it just makes sense, because unless you've carried out your DPIA, you can't know what the risks potentially are and what steps you might need to take to ensure that that processing is carried out in a way that complies with data protection law. So very much the view is at least carry out a high level DPIA on any new project, and then you can work out whether you need to do a further analysis. And what you're essentially doing is trying to look at whatever the new processing activity is, or the changes to it, and try and identify where the privacy risks may arise, where the impact is on the individual, whether too much data is being collected, how it's being held, how you're making sure that you comply with data protection law. Excuse me, and then looking at what steps can be taken to mitigate some of those risks. You don't need to carry out DPIAs for existing processing activities unless it's a change in the risk profile. But the regulators do recommend that a new DPIA is carried out at least every 3 years, which means in practice that even for existing activities, you'll want to think about reviewing those at some point as part of your preparations for GDPR. And it's important this is carried out. It's not just a paper exercise carried out at the last minute. It's important it's carried out at the outset of a project in order to get best value from that. And that will involve your DPO and others within the organisations. But also there's an express requirement to actually get the views of data subjects. So that might be your employees, it might be your customers, it might be customers of your clients, depending on what the processing relates to. So think about how you can actually get their views through maybe a consultation, whether it's formal or informal. How do you get the views to understand what the individuals might expect to be appropriate and what their reasonable interests are, expectations are. The regulators would also like organisations to be transparent here. So they would like organisations to publish their DPIAs, or at least a shortened version, again going back to the transparency principle under GDPR, so that data subjects can understand the approach that's been taken and the steps being taken to ensure that the processing is appropriate. So moving on to transparency, I mentioned that the majority of the legal bases upon which you can process personal data remain unchanged under GDPR. So whether that's legitimate interests or processing necessary for the performance of a contract or to comply with a legal obligation or any of the numerous conditions that are set out in various bits of secondary legislation under the Data Protection Act, all of those are largely moving forward unchanged. The one area where there is a little bit of change is in relation to processing on the basis of consent. And what is changing under that is a tightening up of the rules of consent. So firstly, the consent needs to be freely given. It needs to be specific, it needs to be informed, it needs to be unambiguous, and it needs to be given by some form of affirmative action. So what that means in practice is that having a consent provision that's buried in some terms and conditions or a privacy notice where the individual purports to consent to something happening is not going to be valid under GDPR. Indeed, there are questions whether it's valid under current law, but GDPR makes that very clear that that sort of approach will not work. Similarly, pre-ticked boxes won't work, or relying upon silence. It needs to be an affirmative action. An individual ticks a box or they press a button in order for that consent to be valid. And it's also not possible to bundle up consents together, so you can't say we're going to process your data for this purpose and also this purpose and give the individual no choice over those purposes if they are quite different. So it's important you break those down and look at the consents you're actually relying upon and work out what is appropriate. Organisations need to be able to demonstrate the consent they got. So again, record keeping is important here, recording what an individual agreed to at what point, so you can demonstrate that in the event of a challenge. And there's no grandfathering of existing consents under GDPR. So if you're processing on basic consent at the moment, you will want to ensure that that consent is valid come the 25th of May. And if it's not valid, you'll want to look at how you actually go about refreshing that consent in a valid way. But relying on consent as basic processing gives individuals a number of additional rights, in particular around stopping processing and some other things. And so for that reason, it's now is a good time to actually look at your paperwork and think, well, is consent really the best legal basis upon which to process data? And perhaps there might be another better, more appropriate legal basis that you can rely upon. And I mentioned some of them before, such as processing is necessary to perform a contract or to comply with law. So for example, anti-money laundering checks, there's no need for that to be done on the basis of consent, because if it's something you're doing to comply with a statutory or regulatory obligation, you just tell the individual, we need to do this. You're not doing it on the basis of consent. The second thing I want to talk about on transparency is around privacy notices. So at the moment, privacy notices are used, but they tend to be fairly bland and not have a huge amount of detail in terms of the actual processing that is being carried out. GDPR tightens up the rules on privacy notices, and you'll see on the side there a list of the things that you need to include in your privacy notice under GDPR. So you need to explain the legal basis, which means you need to know the legal basis. You need to explain what your legitimate interests are if you're processing on the basis of legitimate interests. You need to explain any international data transfers that you're making and the steps you're taking to ensure that the data is safeguarded. You need to explain what your data retention period is, or the criteria you use for that. So again, that requires you to know at the outset how long you're going to keep data for, to be able to tell the individual what you're doing. And you need to tell the individuals about their rights as a data subject, so their rights to find out about what you're doing, to object processing, to require rectification, and some of the new rights that come in that I'll talk about. If you're processing basic consent, you need to tell the individual they have the right to withdraw that consent and how they can go about doing that. And you need to tell them they have the right to complain to the regulator, so the Information Commissioner in the UK, if they're unhappy. And all of that needs to be done in a way which is concise, transparent, intelligible, and in an easily accessible form. So there's clear a little bit of attention in terms of that additional detail and making these things accessible to the individual. And I think we'll see the use of things like layered notices, where these are broken down, just-in-time notices, where people are given the right amount of information at the right point. And when do the notices need to be provided? Well, under GDPR, you need to provide your privacy notice at the point that you collect that data, if you collect it directly from the individual. If you get the information from a third party, then you need to provide the privacy notice as soon as possible thereafter, and at least within 1 month. So if you get data from a third party, another controller, then you'll want to actually think about how you ensure that your privacy notice is provided to the individual. Do you rely upon that third party to provide it? Do you have a joint notice, or do you issue it directly to the individual? It will very much depend on what you're doing as an organisation. Data subject rights. So you may have heard about something called the right to be forgotten, which has had quite a lot of press, and the right to erasure. And essentially this is just codifying an existing right under current data protection law, which essentially says that individuals can require organisations to stop or to delete data once they no longer have a legal basis to hold on to it. And it's not a right that can be used to frustrate what you're doing. If you're processing data for legitimate purposes, then you don't need to delete the data. It's simply when you get to the end and you no longer have a legal basis for it, then the individual can require you to delete it. But as I said when I was covering data protection principles, that's something organisations should be doing anyway. So this shouldn't be too difficult to comply with. And indeed, actually, if you comply with the data protection principles, it's unlikely you'll have to deal with many of these requests. The second new right is in relation to data portability. And this is a right that allows individuals to get an electronic copy of their data and port it to another service provider. But it only applies in certain situations where you're processing on the basis of consent or performance of a contract, and where that data is processed automatically. So again, whether it's appropriate to what you're doing will very much depend on the nature of the services you're providing or whatever processing you're carrying out. The third data subject right I want to talk about is subject access requests. And this is a right we've had under current data protection law for many years. But just a few things to flag. So firstly, the 40-day period for complying it's reduced to 1 calendar month. And secondly, the right to charge a fee of up to £10 disappears. So you no longer will be able to charge a fee for it. You'll only be able to charge a fee where the request is repetitive or vexatious or something along those lines. But also individuals will have the right to additional information around how and why their personal data is being processed. And much of that is actually what should be in your privacy notice already, but just to be aware that when you're dealing with subject access requests, it's not just a case of telling them or providing them with a copy of the data you hold, but actually additional information beyond that. As I mentioned, data processors acquire some new obligations under GDPR. They're listed there on the slide, so they need to keep records of what they're doing for the controllers for whom they're processing data. They have an obligation to cooperate and consult with the controllers for whom they're carrying out processing. And there are strict new rules in relation to using sub-processors. So if you're a processor and you subcontract some data processing activities to a third party, then actually the relevant controller will needs to be given the right to object to that sub-processing. So that's something you need to think about how you manage that in practice. Processors also acquire direct obligations in relation to data security. So at the moment, data security sits with the controller, and the processor simply has to comply with whatever's in the contract. But as to whether those measures are appropriate for data protection law, that is for the controller to decide. That changes under GDPR because the processor is responsible for the security measures that are within its control. So if you're a processor, you may want to look at your data security measures and ensure that actually you are comfortable being able to say to a regulator, yes, actually, we've taken all appropriate steps and measures. And that may have commercial consequences for your contracts with third parties and the charges. Data breach notification, there are certain obligations there, so you need to tell the controller if you suffer a data breach. And if you suffer, there's also potentially on the hook for sanctions if you do not comply with your obligations. And finally, just to be aware that there are specific new rules in relation to contract clauses that need to go in to deal with contracts with processors. A list of specific clauses you need to go in there. Again, there's no grandfathering of existing contracts, which means that you want to review your contracts to ensure that they are up to date. In relation to data breaches, there's an obligation to report personal data breaches to the relevant regulator within 72 hours of becoming aware, unless there's no risk to the individuals involved. So what that means in practice is you're going to need to have a policy in place internally to ensure that firstly employees know how to spot a breach, and secondly they know where to report it internally, and thirdly for you as an organisation to work out how you assess that breach and the risk and work out whether it needs to be reported. Because if you suffer a breach on a Friday afternoon, that means you'll need to have notified it to the regulator on the Monday afternoon, which doesn't leave much time. You don't need to notify if there's no risk, but again, it's important to actually understand and quickly investigate the issue. But you potentially also need to notify the individuals if there's a high risk to individuals. So again, working out whether there's a high risk individual is important. You may need to actually tell the individuals that you have suffered a data breach. And finally, just a few words on regulation enforcement. So, as I mentioned, the enforcement powers under GDPR are increased substantially. So the regulators, such as the Information Commission, require new powers in relation to investigations, such as the right to enter premises, to carry out audits, to require information, much stronger than they have at the moment. And they also have stronger corrective powers as well. So that's not just the powers to issue fines, but also powers to issue or to suspend or ban processing, which may have a material impact on you as a business. So think about how you deal with that and the impact of that. Again, this should be driving the correct behaviour. And on fines, there's a lot of scare stories around the size of the fines under GDPR. The €20 million figure, but that is the maximum power to fine. And it's fairly clear that for most organisations, there won't be, certainly what the Information Commissioner said, there won't be a huge increase in terms of the size of fines that are being issued. But there could be fines for lesser offences, so there's a possibility for fines to be issued for administrative breaches, which is not possible at the moment. So again, failure to keep records, to near misses, that kind of stuff could lead to regulatory enforcement action. Okay, so moving on to the last section, just talk a bit about what you should be doing to prepare. The Information Commissioner has issued a very handy 12 steps guide, and certainly if you haven't seen that and you're at the beginning of your GDPR journey, certainly recommend you go and have a look at that. The Information Commissioner's website has a large number of resources on that which are really helpful in helping organisations work out what they need to do to prepare. I'll just take you through what I think some of the key steps are. So firstly, thinking about your resource and your team for dealing with this. So who is it who's responsible? Have you got input from across the organisation, from different departments, to understand how different areas use data and ensuring that you are preparing appropriately? And you've got senior sponsorship as well, whether that is in terms of time, resource, money, or whatever. But perhaps the most important thing is carrying out a data audit or a data mapping exercise of how your organisation uses personal data. Because until you have that clear picture and you understand what data you're processing, for why, and what your legal basis is, you can't work out what you need to do to prepare and to comply, where your gaps are. So a very important exercise to carry that out, and do start it if you've not done that already. I mentioned territorial reach, and again, if you have parts of your business which are outside the EU, just do a quick check to make sure you're aware of whether they are caught with extraterritorial provisions. Accountability, so reviewing your policies and procedures, ensuring those are up to date and they are there to help you be able to comply. On transparency, looking at your privacy notices and looking at your use of consent if you rely upon that, and seeing whether there's a better legal basis, potentially renewing consent if you still need to rely upon that. On data retention, this is not just a case of reviewing your policies, but also now is a great time to actually look at what data you're holding and whether actually you still need it. If you can cull some of that data, it makes your compliance exercise a lot easier. So do take the time to do that. Data protection impact assessments, build that into your process as an organisation. So when you're carrying out a new project, ensure that a data protection impact assessment forms part of that, and you have a clear process to follow, a clear policy for that. Record keeping I've mentioned, so again it's fundamentally important, because if you don't keep records, I think it's very difficult to be able to demonstrate compliance. So ensure that you keep an up-to-date record of your processing activities. Data security, as I mentioned, there's not really much changing there, but I think it's a good time to review whether your current arrangements are appropriate, particularly if you're a processor and where you're now actually, your neck is on the line for whether those are up to scratch or not. And on data breaches, it's about ensuring you have, I say, those internal processes, internal policies that staff can follow, and they're aware of what they should do if they detect a data breach. On the commercial side, look at your contracts with third parties, whether that's with your customers or clients, or other third parties with whom you process data or share data, and understand your legal basis, whether you're a controller or a processor. Look at your technology and whether technology can actually help you to be compliant. So things like access controls for records, your data retention policies where you can automate data deletion, all that kind of stuff can make your life easier. And finally, if you are going out and procuring any new technology, again, think about ensuring that you are following privacy by design. You're thinking about how GDPR, you can do that in a way that makes GDPR easier to comply with. So finally, just, wrapping up with some key actions. To say, important to understand your strategy and your team, but this information asset register, I can't stress that enough as to how important it is to actually do that mapping exercise and actually create that record, because that will be the heart of your compliance. Also important, I think, to understand what your status is. Are you a controller? Are you a processor? And it may be that you have different roles depending on who your clients are and what services you're providing to them. Very much the nature of the appointment, so understand what your status is, and then ensure that your contracts align with that. Review your template documentation, your terms of engagement, whatever it may be, to ensure that they are appropriate for what you're doing. Review your privacy notices to ensure that they reflect GDPR requirements, and you're being clear with individuals, and your processes for dealing with data subject requests. Talked a bit about policies, say it's important to review those, but I think fundamentally, and just as a sort of a closing point, all these policies and procedures only work if your staff and your personnel understand them and are familiar with them. There's no point having a great suite of policies that sit in a cupboard or on a system that no one reads. So staff training and awareness is absolutely fundamentally important here to ensure that everyone is aware of what they should be doing and how they can help your organisation to actually comply with GDPR.
Martin, thank you for that tour de force. That's a really very, very comprehensive presentation. So Now's the opportunity for you to put questions to Martin. I'm going to try and crisply move through the very number of questions that we've received. If you've not yet submitted a question, now's the time to start typing and put your question to us. If we can't cover your all the questions during the course of the webinar, we will be putting out a sort of thematic response to questions and posting that on our website shortly. But let me start with I think the question that takes us to the heart of this. Our first questioner asks, what if I'm uncertain whether I or my firm is a data controller or data processor? What should I be doing?
So I think it's not something that I can answer from here without knowing what services you actually provide, what processing you're carrying out. But what I would do is I go back and look at exactly what it is you're doing. Who is it that has genuinely the decision-making powers in terms of what data is being processed and what purpose it's being processed for? Are you acting solely on the instructions of another organisation, or do you have autonomy in what you're doing? Now, processors can have some degree of autonomy in terms of what they're doing within a certain scope of instructions. But if you have wide discretion, then you're likely to be a controller. And it's helpful to bear in mind the Information Commissioner's guidance on this. So, for example, scheme actuaries who are personally appointed are viewed to be controllers. Professional advisors are also often viewed to be controllers if they have obligations, professional obligations in relation to, say, their client files and their records, which perhaps transcend what they're doing on the
and nevertheless, data processors post GDPR are going to have explicit obligations in any event.
Indeed,
so
yes.
still burdens to be considered, whatever that
That's right.
status.
But it's fundamental to know where it is you say.
Now, a question that's attracted quite a bit of support is this: how is this GDPR system post the 25th of May going to work for companies within the same group? If you've got, as it were, a form of consent for the processing of your data, is that going to make all data available across the entire group, or will each individual company within the group have to have had its own consent structure?
So it very much, data protection law applies on each legal entity will be a controller in its own right, or a processor. So you don't have a group-wide approach. But that's not to say you can't share personal data within the group for whatever purposes. So it may be that you internally subcontract work, so you have an internal processor, and that's fine. You don't need approval to use a data processor. If you are, and this question may well be getting at marketing, where consent is, certainly for electronic marketing to individuals, you need consent. If that's the case, then you'll need to ensure that your consent covers and names each legal entity who's relying upon that. So the wording that you sometimes see people using about, we will, your data may be shared with trusted third parties or other members of our groups, but it's not defined. That sort of wording is not going to work under GDPR. You need to be much clearer if you are getting consent, what it is that individual is consenting for.
And I guess that if within a group you've got very different planned uses of the particular data, that's going to throw into sharp relief the adequacy of the consent, let's say, that the parent company got in the first instance.
That's right. So say you are, an insurance company or a pension company, and you're getting consent to market those core financial services, but you then perhaps have a subsidiary that has an IFA business, then that may well be a different purpose, and trying to bundle together those consents actually.
It's going to strain the consent, isn't it? Absolutely. Okay. Now the next question that we've got is moving us into this question of privacy notices. So the questioner asks if I take on a new scheme actuary appointment, do I have to publish a privacy notice at that time?
Yes, well, you will probably have a standard privacy notice for what you're doing anyway. But what you would need to do is that notice need to be communicated to the data subjects in relation to that scheme, so they know who you are and what you're doing with their data. So as part of your take-on process, you need to think about who it is that actually communicates that to the individuals involved and how that's done, and whether that can be combined with other paperwork that goes out the door, or whether you're doing it separately. So think about how that can be done in the most effective way.
Okay, and there's a related question around fair processing. And again, it's put to us in the context of scheme actuaries. So how are scheme actuaries going to be able to satisfy themselves and make the appropriate disclosures to the members of the scheme about fair processing of data?
So the fair processing notice is your privacy notice. So that
it can cover both areas.
Indeed, yes, yeah. So your privacy notice needs to explain, what your legal basis is for your processing. So whether that is in order, in order to perform a contract, we've got to do this, or whether it's because you're legitimate interest, or you're doing it to comply with the law. So you're explaining in that what your processing is.
Okay. Now, again, within pensions, the next question we've got is that. Is it going to be likely to be the case that the scheme actuary will be a joint data controller, joint data processor alongside the scheme trustees?
So the position on this doesn't change under GDPR. So and it will partly depend on the facts and circumstances of each case, and exactly what role the scheme actuary has, what role the scheme actuary's firm has in relation to administration. But if you have a clear position at the moment, you understand what your position is, then that won't be changed by GDPR, because the definitions of controller and processor don't change.
Right, okay. It's the same on the 24th as it is on the 26th of May.
Yes.
Yeah, okay. Now, next question moves us on to general insurance, and it's around this issue of underwriting profiling. Is GDPR going to have an effect on underwriting profiling carried out by general insurers?
It may do. So the provisions in GDPR that deal with what's called automated decision making, which profiling may be part of, regulate where decisions are made solely on the basis of automated decision making, and that decision has what's referred to as a legal effect or a similarly significant effect. So if it is making a decision in terms of how much someone pays, or whether or not you're prepared to underwrite a particular risk, then that may well be regulated. So interestingly, at the moment, we've had some guidance in the regulators which takes a very strict interpretation of the legislation here. So there's a right to not be subject to this sort of automated decision making, and the regulators have, in their draft guidance, viewed that as an absolute prohibition as opposed to a right to object. And we're waiting to see whether that changes in the final version. But that sort of stuff is allowed if you're doing it on the basis of explicit consent or to comply with law. So it still will be allowed in certain situations, but it is regulated, and that means you need to be able to actually explain to the individual, provide them with meaningful information about how the decision is made and the logic about that. So it's understanding how your algorithms work and being able to explain that to the individual, which may be a challenge.
But I think I'm right in saying that it's hoped that a more definitive position in terms of the ICO guidance on their website should be with us towards the end of April or something like that, we're hoping?
Right. Yes.
Okay, yeah. but so something to be kept under very careful regard, I think.
Yes, yeah.
Okay. Now, we have a related question, and this is to do with what our questioner calls policy level analysis. And so the scenario the questioner is considering is this: where you're undertaking some review work to identify the policyholder number because you suspect that there may be a system error. So being able to, as it were, cross-check to the policyholder number could be quite relevant. Is that still going to be possible in post-GDPR?
Without knowing more of the facts, I can't see why not. But if you are trying to identify an error, I don't see any reason not to be able to do that.
Yeah, I suppose the question may have been intended around this obligation in terms of minimisation of the data you collect, what you're doing with the data, and so on and so forth. But that seems to me to be within the explicit terms of the regulations, in terms of trying to help the policyholder.
Indeed, and there's also a requirement for data to be accurate as well. So that's where the two principles play against each other. And
what do you think is going to happen to GDPR post-Brexit? That's a leading question for you.
So in reality, very little. As a regulation, it will form part of UK domestic law under the EU Withdrawal Bill, which basically takes all EU-derived law as at the date of Brexit and copies and pastes it into UK domestic law. The Data Protection Bill is going through Parliament also tries to deal with some of this stuff in advance. But the government has been very clear that they are not looking for any divergence in terms of data protection law post-Brexit. And the reason for that is the rules on transfers of personal data outside of the EEA, which if you're transferring personal data to the United States or to Singapore or Australia or wherever it may be, there are strict rules to follow. Those don't apply if the European Commission has made a finding of adequacy in relation to the third country. You can have friction-free, easy flows of data. and business has been very clear that the UK obtaining an adequacy decision is of fundamental importance. So the UK is not going to willingly do anything which will upset or risk that not happening. So it very much is here to stay. I don't see any scope for divergence.
And would you agree that increasingly, it seems to me, that European Union law and approach to data privacy, it seems to be a trendsetter across the globe, is increasingly being followed by other jurisdictions?
That's right. So we've seen this with the 95 directive. That a lot of countries which have implemented data privacy laws have very much based them on the EU directive. And the reason for that is to come back to my point around international transfers. And if you base your law on EU law, then you are in a much better place to actually get that adequacy decision. I'm aware of a number of number of non-EU countries who are looking at GDPR, and they are looking at making updates to their current law to ensure that they are keeping pace with GDPR and they can retain that adequacy finding.
Now, our next question asks us to look at a hypothetical situation of a firm that's not 100% compliant on 25th May, clearly not an actuarial firm, I'm sure, but what sort of sanctions might a firm in that position, that it's not fully compliant come 25th of May, what sort of sanctions might you think they expect to get or receive?
So the first thing to note is that the Information Commissioner does not have the resources to go around every firm and ask questions on the 26th of May is a Saturday as well, so you have a couple of days before anything will happen. But even on the Monday morning... You're
going to be okay till Monday at least, I'm
you'll be fine for a few days.
Yeah, okay.
But even then, they're not going to just knock on your door and ask you to produce all your policies and demonstrate compliance. But they will be reactive. They're going to have to be reactive because they don't have the resources to do anything else. But if someone complains and says, well, this company is clearly not complying with GDPR, whatever, that's when questions may be asked. And if the ICO comes in and sees you've done nothing, or very little, or paid lip service to GDPR, then that is where you may well find sanctions are taken. But if you can show you're working towards compliance, then I don't expect the sanctions to be draconian. And the Information Commissioner has tried to reassure business quite a lot over the last year around the approach, and that actually it's not a fine first approach. Monetary penalties will be reserved for those organisations who are just turning a blind eye to compliance. But if you can show you're working towards it, and you're taking a risk-based approach, you've identified where the issues are, you can show what you're doing about them, or you've dealt with the biggest issues first. That will all help in terms of actually your position with the regulator if the worst does happen.
But I think you mentioned earlier through the presentation, and I guess this is back to this context of the significantly increased power to fine, that there is nevertheless an obligation on the regulator, on the enforcer, to make sure their fines, their sanctions are proportionate. That's proportionate to the damage caused by the particular breach or the failure you've made in terms of your preparations. What is it going to be proportionate to?
So you're right. So it's proportionate to whatever has happened and the consequences of that. And we've seen that just now. If you look at the monetary penalty notices that have been issued by the Information Commissioner over the last few years, they all list the aggravating factors and the factors which perhaps suggest a lesser fine should be awarded, and that is all used. There's almost like a tariff approach that they use at the moment, and then the aggravating factors will increase that, and mitigating factors will bring that back down, and that then helps them to justify their petition.
Now a rather focused question next, and that is that, as you may know, the IFOA has a system or a structure of voluntary regional societies. So let's say the Birmingham Regional Society of Actuaries could be approved by the IFOA. Now, will that voluntary regional society, be subject to GDPR requirements in relation to the data it holds on members who've chosen to join the Birmingham Society?
Yes, I think it will be, yes.
So all of the obligations we've talked about are going to apply to that regional society. Yes. It needs to be thinking about what it's doing in terms of demonstrating and being compliant.
That's right. I'm not able to answer whether it is solely responsible for that or if it's part of the IFOA. I'm not familiar enough with the sort of constitutional, the structure of the committees, but that's maybe something to look at.
Take your point. Okay. Well, the clock is against us, and I think we've come to very close to the end of our allotted and available time. If you've submitted a question which hasn't yet been answered, as I said a moment or two ago, it is our intention to provide answers to the themes that have not been dealt with in the various questions, and we'll be posting those where relevant onto our website. Can I also just mention that there is a further IFOA event around GDPR, an event that's focused towards scheme actuaries. It's going to be held next week on the 15th of March, 5 to 5:30, held in Staple Inn here in London. If you can't get to that event on the 15th of March here in London, it will be going up, a recording will be going up on the IFOA's website a few days after that. So we'd be delighted to see you there. As I say, an event primarily focused on GDPR and scheme actuaries. But beyond that, can I do two things? Thank you for your questions and your participation in this webinar, but in particular to thank you, Martin, for, as I said, a comprehensive presentation, which I think has been really very, very useful, and I hope you found it useful too. Thank you for that presentation.
Thank you.
And thank you all.